If a decision is made to depart, we make plans, as you might imagine. We always make plans for different contingencies. And so we will continue to make plans and prepare whether we stay or depart. What I would tell you just on the impact of counterterrorism, since the events in July, that has impacted our ability to support our counterterrorism. And as we look to the future, we will continue to look at the other nations within West Africa, as well as some of the allies and partners that actually are working counterterrorism. And matter of fact, I had a chance to sit down with a couple of the chiefs of defense that are also working counterterrorism in West Africa as well, to talk more holistically about our approach as we all work together, as we do, just like we're here working on Ukraine. Thank you.
Thank you, gentlemen. Our final question will go to Aisi Tabi, Al Jazeera.
Thank you, sir. I just follow my question of my colleagues about Gaza. Over the past 24 hours, Israeli army has carried out a series of airstrikes in the city of Rafah, leaving dozens dead and injured. As you know, Rafah hosts 1.5 million civilian, and we know that Mr. President Biden urged Israeli Prime Minister Benjamin Netanyahu not to launch an attack on Rafah, but the attack is going on. My question to you, sir, what's your position now in this military Israeli operation on the ground right now? Thank you, sir.
Well, thank you for the question. And, we've been clear about the need to prioritize the protection of civilians, and that a military operation should not proceed without a clear and implementable plan to evacuate those civilians out of the battle space and also care for them once you evacuate them. Now, we've communicated this a number of times from the president's level on down, and certainly, I've communicated with my counterpart a number of times. So that should be a key part of any military, any plan, any type of operational planning to account for and protect those civilians that are in the battle space. And again, we've yet to see such a plan, but we'll have an opportunity to engage the leadership here on that soon. So.
Secretary Austin, General Brown, thank you both very much, gentlemen. Ladies and gentlemen, this concludes our press briefing. Thank you very much for joining us today.
fraud provisions. Not just a concern, they have an interest, a material interest. If they get the anti-fraud provisions, they're better off. If they don't get the anti-fraud provisions, they're worse off. Now, what I hear you saying back is they had no pre-existing entitlement to the anti-fraud provisions, and your test is one that says if they're not being made worse off by the plan, then they're not an interested party. But I don't know why that should be the test. If I look at the language, that's not the test. If I think about what the ordinary meaning of being a party who's interested is, that's not the test. Why is your test, so long as they're not being made worse off, they're not an interested party?
Well, the test of whether there is a benefit I would like to get out of the bankruptcy case, which is Truck's test, is unlimited. Anytime you can imagine a hypothetical plan that would be better off for you.
That's a practical concern, and
Well,
I think, the practical argument against it is it's pretty costly to enter into these proceedings, and nobody really does it unless they have a serious interest. And anyway, bankruptcy courts have docket management techniques. And anyway, just putting aside the practical concerns, is this a floodgates problem or is it not a floodgates problem? I don't really see why your test, which is are you being made worse off or are you being made, or is it, are you just being held to the bargain that you initially had? I don't see why anybody would think that that's the way to answer a question of whether you're interested in a proceeding.
Party in interest is a term of art that means you have an interest in the debtor's bankruptcy estate. That's been the meaning for 100 years. And so that's the way to start. But if we're going to think in terms of seeking to obtain a benefit in the context of causes of action, or Lexmark, zone of interest, the question is always, have you suffered a loss? If you've suffered a loss, you come in and you try to get a remedy. What Truck is saying here is I can come in, even though I'm suffering no loss at all to my legal rights, and just seek to obtain a benefit because it's very nice that this bankruptcy is here and maybe I can get something out of it. But even if they don't have the right to come in, there's always permissive intervention. So there's the right to come in as an interested entity that's not a party in interest. The benefit of that is it's in the discretion of the bankruptcy court. You have to show cause. The bankruptcy court can decide whether you come in for all issues or just some. The question is who has the right to intervene in the case.
Would you object to permissive intervention in a situation like this, where the insurer's seeking fraud prevention?
We would have objected to their attempt to come in and object to the merits of the plan, but they
That
certainly
wasn't
have
the
the right.
question.
Yes.
The question was
They could have sought to pursue permissive intervention under 2018 to get to the merits of the plan.
Would you have objected to
We
that?
probably would have opposed that
Why?
for all the reasons that we're otherwise opposing.
You just don't want them to be heard.
They have the right to be heard.
You don't want the
ensure they
fraud
aren't.
prevention provisions, but you don't want them to be heard on that. Is that, I mean, that's okay.
Well, all of the lower
just want-
courts, I mean, they were heard on that. All the lower courts ruled against them on the merits as well, but the bankruptcy and the district court, although the Fourth Circuit didn't get to it. It's good to keep in mind, if we're going to be talking about the policy concerns, that bankruptcy is just not about get everybody to the table. It's also about having an efficient and expeditious proceeding that makes it possible to resolve what is ultimately a question about the debtor and its creditors, or in some cases, its shareholders.
Well, it may not be about getting everybody at the table, but you do want all the creditors there, don't you?
Yes, you do want all the creditors
Well,
there.
they're a creditor.
As to the plan that's at issue here, they were an unimpaired creditor, and an unimpaired creditor does not have the right to object to a plan. That's Section 1126F.
But at the time, Mr. Marshall, the language, you agree that they had an interest in the plan finding, right? About the good faith and about whether this was going to be collusive. Everybody said below that they had an interest in
The plan finding was a threshold question that they certainly had the right to litigate.
Right. And they did have an interest as a creditor because of the deductibles that were due, right?
They were a creditor. As to the plan at issue here, they were unimpaired and
Okay,
didn't have the right
but
to
that's
object.
looking ahead to the plan. I guess what I want to say is that 1109B says that a party in interest, including our list, may be heard on any issue in a case under this chapter. So if they can be heard on the plan finding, or if they're a creditor, I guess I don't understand why on the text of that provision they can be so limited and say, well, you can't bring up anything else, even though the text says any issue. It doesn't limit it in that way.
I'll address that in two respects. So the plan finding, again, is the question of whether they are a party in interest in the first place. It's a threshold question. It's like deciding jurisdiction or statutory standing. You have to get through that to get to the merits. So as an insurer, nothing about the plan finding changes whether or not Truck is a party in interest. They're not. As to a creditor, we're talking about the right to object to a particular plan that leaves them unimpaired. And although 1109B has that general language, 1126F more specifically says that an unimpaired creditor is conclusively
Mr. Marshall,
presumed to have
maybe I'm not
accepted.
understanding about the plan finding. I mean, it's true that at the end the court said that Truck wasn't harmed, but what if the court had decided otherwise? In the beginning, they don't know whether it's going to be collusive or violate Kaiser's duty of good faith, right? Maybe I'm just misunderstanding. I mean, it went in your favor, but
Party in interest status is a threshold question. You have the right to come in and litigate whether you're a party in interest or not. And that's all the plan finding did. It determined that their rights were not abridged, and therefore they were not a party in interest. If that had gone differently, then yes, they could have objected to the rest of the plan to the merits.
Mr. Marshall, you've agreed that they were a party in interest to the extent they were a creditor, right?
Yes.
And normally a creditor or a party of interest can be heard on any issue. You agree with that?
That's the text of 1109B.
Okay. And you've been citing 1124 and 1126 to us. I understand and appreciate that, but that governs who can vote, right?
That is what it explicitly says, yes.
It doesn't talk about what they can argue about or be heard on, right?
It says they're conclusively presumed to have accepted the plan,
right.
And an inference from that is that it would be absurd to vote
So if you can't vote, you can't be heard. Is that your argument then?
You can't be heard on the merits of the plan. And that's what the circuit courts have said. We cited cases, and Truck cited some cases allegedly to the contrary, but they're actually not, because all they do is determine whether the creditor that wants to object to the merits of the plan is actually impaired.
Thank you, counsel. Justice Thomas? Justice Sotomayor? Justice Kagan? Justice Gorsuch? Justice Jackson?
Can I just ask one question? At the threshold, you keep saying at the threshold, they have no interest in the estate property. Do you dispute that they have a potential to have an interest in the estate property, that insurers do? Because the plan isn't in existence yet. Do you dispute that they have the potential?
Borrowing from intervention law, the question would be, when is their interest put at issue? And it's somewhat like which would be, is a plan proposed that would breach your contract and give you an interest in the estate? And it's analogous to what the actual history is with executory contracts. So the statutory history that the government invokes actually suggests your party in interest when there's a motion to reject an executory contract, because that would create a claim, a breach, and make you a creditor.
I guess I don't understand your answer.
So, when it's put at issue?
When it is put, why isn't it put?
If you're an insurer, you're not in the list. Nothing makes
right,
your
but
party
the list says including, so we know there are things that there are entities that may not be in the list, right?
Correct.
Okay, so the question is, they come to the table at the beginning and they say, we think we should be in the list because we have a potential through the reorganization plan that will be adopted to be affected. And you say not party in interest because you're not already affected, or it's not clear to us right now that you're affected. Is that your position?
If we're talking about Truck as insurer?
Yes.
Yes.
All right.
But once a plan is proposed that would breach your contract?
So can I ask you, if people who are not potentially affected are not parties in interest, I guess I don't understand Congress's suggestion that parties in interest should be a part of the reorganization. In other words, the context in which what's valuable to them about being a party in interest is the fact that they then get to talk with everybody about how this is going to go. And the problem I'm having with your argument is it suggests that it's only after we know, or after they know that they're definitely affected, that they get a seat at the table. But the whole point of it is that the parties in interest get to talk about it. So it seems to me it would have to include people who have a clear potential for being affected by the plan that we're all hammering out in this discussion.
There's nothing in 1109B itself that says that has to be determined for once and for all at the outset. And if we're talking about someone who's not in the list, the only way to know if you're party in interest is, do you have an interest in the bankruptcy estate?
Thank you.
Thank you, counsel. Mr. Frederick?
Thank you, Mr. Chief Justice, and may it please the Court. There are a number of questions I'd like to address that you posed this morning, but I want to start with one principle, which is that the Bankruptcy Code was not intended to protect insurers except in a couple of places where asbestos-related trusts are created. Those are in Sections 524G principally. But in 109, Congress said an insurer can't invoke bankruptcy for protections under the code. So, Justice Kavanaugh, to your question about the text and practicalities, Congress answered the question of whether an insurer should be permitted to butt into a debtor's bankruptcy and try to use it to protect its own financial interests. The bankruptcy process is designed to ensure that the debtor can maximize its assets for the benefit of creditors. And so what the insurer, as insurer, is doing here is seeking to co-opt the debtor's bankruptcy for the purpose of protecting its own interests. Justice Thomas, I can start with the timing question if you like.
Well, you can start with that, but also I think that their interest isn't so much in feathering their own nests, per se, but rather that they be treated with the anti-fraud provisions the same way that the claims under the trust are being treated.
Yes, and let me start with I'm going to call these pretrial disclosure requirements because Truck had 6 months of discovery to try to prove any fraud with the Kaiser claimants and came up with crickets. What they are calling anti-fraud prevention measures are really requirements to impose on state courts that before a claimant can file a claimant has to comply with what Truck wants for information that a state court might or might not require under state court rules of procedure. So if you were to accept the idea that their nomenclature drives the outcome here, you're essentially saying bankruptcy courts have the authority to tell state courts how to do their discovery process. And Justice Barrett, that's why we're fighting this. Because the claimants shouldn't be required to impose on themselves and their families a lot of information that if Truck really wanted it, he could ask for it in state court discovery proceedings, and state court judges could decide is that relevant or burdensome or not.
Why do all these other circuits and other bankruptcy courts impose it? If they felt the same way that you're arguing, are they violating the bankruptcy code or disrespecting state courts because that's what they require?
No. The requirements here are only for a very small class of claims that are called extraordinary claims. And they are extraordinary claims, and it's defined at JA 427 under the plan. These are not insured claims where the claimant is seeking to say that Kaiser was responsible for the vast bulk of its exposure to asbestos. And in that very unusual circumstance, which actually in the implementation of this plan hasn't arisen yet, the requirement is for that claimant to come forward with proof of a negative, that it hadn't been exposed to asbestos by any other potential tortfeasor. And so we're talking about a very narrow class with a description for a very particularized purpose that Truck wants to appropriate and force so that claimants will have less of an opportunity to invoke their jury trial rights in state court, which are protected under the U.S. Code.
Why should you, as the debtor trust, have that advantage and not give it to them?
Because
that's the difference in treatment that they're claiming is contrary to the plan.
It's not for this reason. The treatment by Kaiser of Truck is exactly the same before bankruptcy as it was now. Truck agreed
but bankruptcy
contractually.
Changes everyone. It changes who the debtor is to the trust. It by its own terms, it's extinguishing the debtor's obligations to anyone, except under the extant contract. But the incentives are different. There's inherent change
That's why the principle of insurance neutrality, which was developed 30 years ago in the courts of appeals and has actually followed in every single court of appeals that has addressed this question, has looked at whether the insurer's legal obligations are altered, and if they are not.
Then circle back to my initial question. Other bankruptcy courts have imposed these same requirements, and they've done it. Are they breaching bankruptcy law? Are they stepping on state courts in an improper way? What are they doing? And why are you fighting something that you admit your claimants in discovery might well have to give up?
Because it's up to the state court to decide that.
Why?
Because they're the ones that will be superintending discovery.
But what does that have to do with the cost? What does that have to do with anything? Meaning, if you eventually, in most jurisdictions, will have to give up something like that, because there is very few jurisdictions who would say they have to pay the entire cost if there's multiple exposures, or they have to pay the entire cost if other people have paid you. That's all that's being sought.
It's more than that, Justice Sotomayor, which is why they're fighting so hard for it. And I want to make this very clear, that the point of the extraordinary procedure is because the trust itself is having to pay the claims. They are not insured by definition. And
that's the whole point. You're trying to give yourself something more than you're giving someone else, and you want to reach into their pocket and say, I'll give myself more than you.
Because the contract of insurance, which they litigated for 19 years in California state courts, definitively determined they will have to pay the claimants who are insured.
So I think I'm getting the equities of this, Mr. Frederick, as you describe it, is that they had a contract and they've been protected as to that contract, and they're just looking to get a better deal now and to kind of take advantage of the bankruptcy. So I'm getting the equities here. I'm not getting where you derive from the text the idea that they're not parties in interest because they have a material interest in what comes out of the bankruptcy proceeding, and they can improve their position materially in the bankruptcy proceeding.
The cases that we cite historically under the Transportation Act of 1920 make very clear that if you're just seeking a benefit, you don't get party in interest status. You have to show aggrievement and harm to your pre-position.
So those are some 1920s cases. Do you have anything in the text that can suggest that the text has incorporated that view?
We don't have anything like that, although I would point to the history that the debtor's brief very helpfully lays out, which explains how the origination of the bankruptcy code went through these iterations and accepted those principles for party and interest. And I think that it makes sense from an Article III perspective, too, because the other side is essentially saying Article III has no role to play here, where a bankruptcy process is a multifaceted fight over a res. What is the debtor's estate? Who gets that property? And so those claims are going to be somewhat flowing in and out. And it is imperative in the 524G context that you recognize Article III has a role to play. Why? Because the district court has to enter the final injunction. The bankruptcy court does not have the authority to do that under the statute.
Mr. Frederick, I certainly get your arguments and why they might persuade a bankruptcy court to rule for you and not require these anti-fraud provisions. But I think you've admitted that a court can do those provisions, and they have done them in other cases lawfully, right?
For the trust's benefit, but not where there's an insurance neutrality clause.
So the question becomes, can they be heard? That's the only question before us. Can they be heard at all? And I guess I'm struggling on that one. We're not discussing the power of the court. We're not discussing what it might rule. We're only discussing who can be heard. And I think you have to acknowledge that there are creditors who can be heard, even if it's a virtual certainty that they will get nothing, or a virtual certainty they will get 100 cents on the dollar.
Right.
They still can be heard.
They can be heard until the point where their impairment is determined.
Well, they may not have a vote, but they can be heard on any issue. No?
Until their impairment has been determined, Justice Gorsuch. That's the key point.
Where do you get that from?
1126F.
That's who votes.
But the point of voting is who can hear, and the whole point of the chart, which you can see the bankruptcy court's determination, is who's impaired or not, because the bankruptcy court has to get to an end place. There were a dozen insurers here, and under their position, there is no limiting principle to any of those insurers who could continue to fight because they want to get benefits out of a bankruptcy process that Congress foreclosed.
Do you agree on Article 3 that's with respect to a plaintiff coming to court and not with respect to those who object under bond?
No,
Clapper?
I don't agree with that.
You disagree with Bond and Clapper on that?
I think Clapper is actually more helpful for our side.
What about Bond?
Justice Bond, I think that the point is where the effort by the objector in this situation is seeking to get a benefit and must show under Article 3 that it has injury in fact that is redressable and traceable to the plan. Here, Truck can't satisfy either because its redressability problem is really because they think state courts are not going to be adequate to police fraud, and they are not able to trace their harm as insurer to the plan because of the insurance neutrality provision. And so I think there's a very serious Article 3 question here that Truck has essentially glided by in this argument this morning, but I want to urge you to take that very seriously because it can't be the case that we have like a law school seminar, anybody who wants to come and talk gets to talk. The whole point of a bankruptcy proceeding is get to a confirmed plan. And the only way to do that is to weed out the people who have something that they want to say and to have different threshold provisions. So, Justice Thomas, I wanted to get back to your timing question. At the disclosure statement, the debtor has to present a plan that is where the issues of insurance neutrality typically are going to be addressed. And at confirmation, we are knowing then that the creditor is impaired or not impaired. So those are the two key timing mechanisms. It can't be at the outset of a bankruptcy because there isn't enough known about the nature of the estate.
Well, if he's not impaired, doesn't he have an interest in making sure that doesn't change?
He does, but that's where the confirmation of the plan comes in. And that's why if you look at the chart, Mr. Chief Justice, this group is unimpaired, this group is unimpaired because they are paid in full. And Truck was paid in full for its premiums. So it is not an executory contract, which under the Vern Countryman definition was where there was lack of performance on both sides of the contract. Here the debtor performed on the contract. The debtor paid all the premiums. And so it is a non-executory contract, which I think helps give the lie to the government's position that calling something an executory contract is somehow going to solve the problem here, where you've got performance that is occurring at different levels and at different stages. And that's why the DOJ policy manual itself says be very careful about invoking executory contracts because they are not defined in the bankruptcy code, and it's very difficult to know how to administer them in practice. And so for the government to be suggesting that you have a test here that is so malleable, where the interests of claimants and creditors is critically important to understanding how to weed out the various muckrakers, where and I would point you to the policy holder's brief, pages 12 to 14, which talks about just how long the insurers have an interest. Why? Delay is profit maximizing. Every day insurers do not have to pay on their claims is a good day for the insurers. And so they have every incentive to tell their lawyers, go in and object to everything because that will delay the process. We could have had this plan confirmed 5 years ago. The only objector was Truck. Every other insurance company agreed to the plan. And so by adopting some rule that everybody gets to be heard and everybody gets to participate.
Truck on the hook for the majority of claims?
Truck and other insurers.
But isn't Truck responsible for the lion's share?
That's what they say, and I have no reason to doubt it. But Justice Barrett, where do you draw the gets it? We heard the
I was just saying that it means less that other insurers didn't object if they didn't have the same stake in the claims.
We don't know what the comparative issues are. The excess insurance part is under a confidentiality standard that I have not seen, and I can't tell you in court what that entails. But what I can say, Justice Barrett, is that it can't be a size issue Because there's no way to draw a line on a size issue. Where do you say it's a quarter is enough, or 6 insurance companies that each have an equal stake is enough? How do you?
Can I ask you a timing question? Can you be a party in interest? I'm just trying to understand your point about how things change as a plan's develop. Chief, do you want me
Sure.
to
No.
stop?
Go ahead.
Can you be a party in interest at the beginning and then not be a party in interest as it becomes clear your interest isn't impaired? Is that what you're saying?
I'm saying that impairment is treated differently. So you can be a creditor and a party in interest, but you are not allowed then to vote on a plan and thereby exercise your voice through your vote.
Okay.
The code treats that differently, and it's odd to suppose that an unenumerated party like an insurance company is treated better than an insurance than a creditor.
Thank you, counsel. I just want to follow up. You were just making the point that you can't draw that line. I mean, the law does that all the time, right? I don't care where it is, and it may be the majority or a significant part of it or whatever.
And that's why I think looking to the guidance of the courts of appeals is actually humbling at one level, but also instructive. For 30 years, courts of appeals have looked at this idea of insurance neutrality to determine whether a plan is materially altering pre-existing legal obligations. In those cases where the court has said, yes, it is, insurance companies are allowed to be parties in interest. That's the Thorpe case out of the Ninth Circuit, the Global case out of the Third Circuit. But in those situations where there's an insurance neutrality provision and the insurance company is not able to say with any proof that its legal obligations are materially altered, the courts of appeals have said, you're not a party in interest.
Well, wouldn't Truck want to have something to say about the division that you've just cited?
And they do, Mr. Chief Justice, because that issue is litigated. When my friend was talking about this being at the threshold, the whole question is the insurance company's legal obligations, are they impaired or not? And that fight is a very vigorous fight.
But that fight continues beyond what you're calling the threshold.
It does and it is, but at a point where the plan is confirmed and we know there will be insurance neutrality and we know that their rights as a creditor are not giving them a right to vote, at that point it should stop. And the 4 years that we've spent doing appellate litigation here ought not to be necessary.
Justice Thomas? Justice Sotomayor? Justice Kagan?
Can I just ask, because you called them muckrakers, the amicus brief for the professors on the other side, and you can just respond to this, says, indeed, when an insurer faces millions of dollars in financial liability, like petitioner does here, common sense and fundamental bankruptcy policy dictate that it be considered a party in interest in the bankruptcy proceedings. So you can just, I mean, this is repeating what you've said probably, but that sounds different from muckrakers.
Well, what I would say, Justice Kavanaugh, is that a party in interest has extraordinary rights. They have the right to contest the trustee, the appointment, the powers of the trustee. They can object to the lifting of the automatic stay. They can ask for the elimination of the plan. They can ask for the transformation of it from a Chapter 11 to a Chapter 7. And those powers and rights are very powerful, and they take bankruptcy courts an enormous amount of time to thoughtfully and conscientiously work their way through.
Thank you. Justice Barrett? No. Justice Jackson? Thank you, counsel.
Thank you.
Ms. Ho, you have rebuttal.
Thank you, Mr. Chief Justice. 3 points, 2 quick and 1 a little bit longer. 1, just to really underscore 1126F, that is about voting. That is not about what 1109B about, which is being heard. 2 very different things. Number 2, on intervention. Congress did away with the requirement that parties in interest must intervene when it replaced 206 and 207 with 1109B. And 3, my friends have talked a lot about the insurer in this case trying to get something out of the bankruptcy or seek a benefit. Trying to stem the tide of overinflated claims is not seeking a benefit. It's just trying to make sure that the plan complies with the code, as bankruptcy judges have an independent duty to ensure. And even if you disagree with me on that, it's undisputed that Truck is going to pay the vast bulk of claims in this case, that the plan finding adjudicates Truck's insurance rights, that truck is a creditor because the insurance deductible. So it really is a party in interest several times over. And I haven't heard from my friends on the other side any justification for reading any issues out of the text. 1109B gives stakeholders a voice, not a vote, and certainly not a veto. We would respectfully ask the court to reverse and remand.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
Okay, gentlemen, this is the center line. Half of you are going to be left, half of you are going to be right, and you'll squeeze together. Executive committee. There, that's my, I'm tired of your chair.
I'm sitting here.
I'm stuck at the table. It's on 4 and 4. That's right, 4 and 4. You look good. Feel like I'm here, so that's
supply chain issues and operations and all that.
what she represents. Half of it Dallas. I'm sure. Dallas, Collin County, Reno. There's elected districts split in the county. Sometimes 3 representatives because one university, which is good, and this is good. Multiple people's representation, and it leads to interesting
Mic check test, testing 1 2, 1 2 test on this microphone, 1 2 test, test test test, microphone check, testing here on the microphone, 1 2, 1 2, microphone check, test 1 2, testing here on this microphone, 1 2 test, microphone 2, mic check test test, microphone check, test 1 2, 1 2 test, microphone check. Test, test, microphone.
Well, thank everybody for being with us here today, and a very special thank you to the University of Texas at Dallas for one, everything they do for education in our state, but for another in particular, what they do concerning the devotion to both educating students in the broad area of technology, but also working with the private sector. So we have a public-private sector involvement and engagement to make sure that we as a state and UT Dallas as a university are working in collaboration with our employers, especially in the high-tech arena, to ensure that those employers are going to have access to the very best educated and trained talent in the United States of America. But that's why we're here in a way. We're here in a way to connect the dots between higher education, technology, and in particular, advancements by the state of Texas in the area of semiconductors. And I want to express my gratitude for people who have been involved in helping Texas take this next step. They include speakers here today, which includes Speaker Phelan, Dr. and Representative Greg Bonin, Dr. David Daniel, members of the Texas Semiconductor Innovation Consortium. And I have a note passed on by Lieutenant Governor Dan Patrick, who wanted to be here and strongly supports the initiative, but had another obligation and could not be here with us today. But wanted to highlight, as you would recognize, the role that Senator Joan Huffman played in making sure that we got this legislation to the finish line. To be succinct, today is an historic day. It is historic as we announce the Texas Semiconductor Innovation Consortium Executive Committee, as well as detail how the new Texas CHIPS Act keeps Texas in the lead among states in the United States of America for semiconductors. Texas, as many people know, is the birthplace of the semiconductor at Texas Instruments. And we remain the #1 state in America for semiconductors. We're home to the colossal fabs like Samsung and Texas Instruments, in offices of Dell, AMD, Oracle, Tesla, and so many others that are on the cutting edge of using semiconductor elements, especially as they tap into it for purposes of AI or artificial intelligence applications. In Texas, we provide a young, growing, and educated workforce for innovators, as well as unparalleled infrastructure to ship completed chips across the entire world. A lot of people don't know. Texas ranks #1 in the United States for exports of technology for 10 years in a row. We also rank #1 in the United States for exports of semiconductors for 12 years in a row. We are going to use that infrastructure that we have and use it in a way to benefit the semiconductor sector unlike any other state in the country. The Texas CHIPS Act, it creates the Texas Semiconductor Innovation Consortium, as well as the Texas Semiconductor Innovation Fund. It will leverage federal CHIPS Act money to promote microchip production. It will tap into the expertise of colleges and universities as we expand workforce training. It will attract public and private investment for the semiconductor industry in Texas. And it will maintain Texas's leadership in semiconductor research, design, and manufacturing. Our future already is filled with microchips, and we are just getting going in that process. They are already in your cars, your watches, your refrigerators, medical devices. Basically, everywhere you turn, you are engaged with something that has a microchip in it. That is just going to accelerate in the coming years. With the leadership of Dr. David Daniel and the hard work of the consortium, Texas will lead the way in research, design, and manufacturing of microchips for generations to come. Now I'd like to turn to the Speaker of the House, Dade Phelan.
Thank you, Governor.
thank you, UT Dallas, Dr. Daniels, everyone for being here. I told it was a chip party, and the governor was supposed to bring queso. I brought boudin dip. It goes well with chips as well. But hey, he talked about the numbers, and the numbers don't lie. We are number one in manufacturing in this nation. We're number one in exports in this nation. We're number two in jobs, 45,000 jobs here in Texas. And we're not satisfied with being number two. And that's why we have the CHIPS Act, and that's why we have this consortium. We want to be number one in jobs, too, and we will be. I want to thank the partners in higher education who are here. You're a vital piece of this consortium, and as we go forward, the blueprint for the future of Texas and this industry. $1.4 billion, I believe, Dr. Bonham, has appropriated this past cycle specifically for this purpose. I got to meet Dr. Lynn from Beaumont, Texas. I represent Lamar University. Dr. Lynn, thank you for being here. Universities across the state of Texas will benefit from what we did this past session. I also want to thank Senator Cornyn and Congressman McCall for what they did at the national level, realizing what's going on between China and Taiwan. That is not a mistake. Whoever controls the chips controls the future of this world, and Texas needs to control the future of this world when it comes to this technology. This is about national security. It truly is. There's a reason why you couldn't buy a car for a year at one point, just a couple years ago, because they have about 1,000 chips in them. We need those jobs. We need that technology right here in the state of Texas. Dr. Bonin, I appreciate Dr. Bonin and his efforts. He led the charge in the House, of course, Ms. Huffman in the Senate, and the whole legislature and the governor's appointment to the consortium and my appointments. Thank you all for being here. This is the future of Texas. We're sending a very clear message that Texas is not going to, we're not satisfied being the leader in this nation. We want to be the global leader in this technology, and it starts today. So it's a beautiful day here in Dallas, beautiful day at UT Dallas. Thank you again for having us, and I'm really looking forward to the future of this industry. Thank you. Okay. Now, go ahead. Dr. Greg Bonin.
Thank you, Governor. And I want to thank the Speaker for his leadership, which was unwavering on what is really an issue not only important to Texas, but it's important to the United States of America. We went into session understanding that at the international level, we have a vulnerability when it comes to the manufacture and production of semiconductors. And Texas is the leader in this area. Our federal partners made a huge investment to try to address what was a real strategic concern in addition to an economic concern. And that's what led to the formation of the Texas CHIPS Act. And when you look at what we did in the last session with the governor and the speaker and the lieutenant governor, there were huge steps that were taken forward. The whole idea here is that, yes, we lead the nation, but are we doing the best that we can? And the answer is we can do better. And that's why we put this organization together to form a strategic plan to look at our strengths, our weaknesses, the opportunities that we have, and also the challenges that we face. And having a strategic plan, we will then be able to go into future legislative sessions knowing what action items the legislature needs to make. And so often we have people doing really amazing work in this state, but maybe they're not communicating. Maybe they're siloed or working in parallel. And they can come together and find synergies that make everyone stronger and everyone better. So I'm really excited about the work that this group is going to do, because this is a beginning. And what we'll end up with is an organized, focused plan for the semiconductor industry and research and training in the state of Texas. We have some of the most expert leaders in the world in this state when it comes to the private sector and when it comes to higher education. And to have them partnering and sitting together in the same room thinking about how we keep Texas and the United States of America number one is an awesome thing. Again, I thank the Speaker and Governor Abbott for your leadership and your support on this, and it is a great day in the state of Texas.
Thank you very much. And now, Dr. David Daniel.
Thank you, Governor Abbott. First of all, thank you very much for appointing me to the Executive Committee of the Texas Semiconductor Innovation Consortium. I want to thank my fellow committee members standing behind us all for selecting me as their chair. It really is a privilege to work with such a distinguished group of individuals. I also want to thank the Governor's Office of Economic Development and Tourism, and specifically the Executive Director, Adriana Cruz, for their support as this committee gets going. They've already done a ton of work to help us roll out smoothly and quickly. I, too, thank the University of Texas at Dallas for hosting this event. It's an extraordinary institution with superb research, education, and a commitment to support the North Texas semiconductor enterprise and the broader community as a whole. One of the characteristics of this industry that strikes me is its complexity and the fact that it's such a globally competitive industry. The complexity is in part technical, advanced materials, research, design, nanoscale measurements, machine learning, just huge numbers of complexities. But at the same time, there are other key elements like supply logistics and work that touch everyone, not just the geeky scientists in the clean room such as the ones behind us. In other words, the work we're doing, I think, has the potential to touch everyone's lives. And as was mentioned, semiconductors, Governor, are part of everything. Our phones, our watches, which just adds to the complexity in terms of manufacturing chips to meet needs that cover the full spectrum of microelectronics, an amazing array of usages, and even the way semiconductors are assembled or packaged turns out to be extremely important as to their utility. And on top of all that, success cannot be achieved without exceptional people. Exceptional people from PhD level to technician and everything in between. We know that Texas has the people to succeed today because we are succeeding, but as these industries grow in Texas, we're going to need thousands, maybe tens of thousands of additional Texans contributing to the success of the semiconductor research and manufacturing enterprise. And we'll need to figure out how we're going to meet those specific job needs in order to make this vision a reality. So I think one of the challenges for the Executive Committee will be to recognize these myriad of contributors to this ecosystem and figure out strategically how we can take the resources that the legislature has made available to us and put them to work in a way that maximizes the benefits for Texas and Texans and helps us build the future that we all want to see. I would just say that I'm very excited about the opportunity to do that, particularly in light of the enormous expertise represented in the group of people behind me. I mentioned that this is a complex enterprise. Well, this group of people has expertise in the details of almost every element of that enterprise, and also the years of experience to see and understand the big picture so that the dollars are invested wisely. The Executive Committee's next steps are to meet this afternoon right after lunch and get to work. Our key action items are hiring an executive director, developing criteria for deciding on which projects we're going to fund, and working collaboratively with our consortium members to develop a strategic plan so that the investments will be consistent, logical, and effective, and will lay the groundwork, hopefully, for many years in the future to help us succeed. We know that the competition is keen, but the Executive Committee is committed to moving forward as quickly as possible and doing our best to help Texas win. Thank you, Governor Abbott.
Absolutely. Thank you, Dr. Daniel, for your expertise and your leadership here. And in a way, I realize today is a beginning as you have your first meeting and you go about the process to implement everything passed by the legislature. But also realize you're getting a running start. Because Texas does have such a leadership position in this, not just nationally, but internationally. And because we have both a massive hub for semiconductor manufacturing and shipping, as well as the technology that goes into it, and because the advanced platform that Texas is operating on. It ensures that, you mentioned the word competition, ensures that Texas will not only be competitive, but will succeed in that competition, whether we're competing against other states or other countries. Because we know, as Dr. Biden put it very profoundly, we know what is at stake in this race. And what we will do is ensure that we win this race. Thank you all very much.
Thank you. That's all we have time for. Appreciate it. Thank you, guys. If you have any questions, you can ask our next event. Thank you.
What time are you heading now? I'm only be here until 4 or 5 o'clock. I'll bring it to see you. You're 1 o'clock. It's great seeing you.
Are you coming back? Are you coming back for this?
I mean,
If anything, it's like
further back, so you.
I'm saying for 1:30.
I'ma keep on running, cause the winner don't quit on themselves. I'ma wade through the waters till the tide don't move. I'ma ride through your borders. Call me bulletproof. Lord, forgive me, I've been running blind and true. I'ma wade through your shallow love till the deep I know. I'm telling these tears go and fall away, fall away. Oh, may the last one burn into flames. Freedom, freedom, I can't move. Freedom, cut me loose. Yeah. Freedom, freedom, where are you? 'Cause I need freedom too. I break chains all by myself. Won't let my freedom rot in hell. Hey, I'ma keep on running, 'cause the winner don't quit on themselves.
Ten Hail Marys, I meditate for practice. Channel 9 News tell me I'm moving backwards. 8 blocks left, death is around the corner. 7 misleading statements about my persona. 6 headlights waving in my direction. 5-0 asking me what's in my possession. Yeah, I keep running, jumping the aqueducts, fire hydrants and hazardous smoke alarms on the back of us. But mama, don't cry for me, rap for me, try for me, live for me, breathe for me, sing for me. Honestly, guiding me, I can be more than I gotta be. Still from me, lie to me, nation hypocrisy, code on me, driving me wicked. My spirit inspired me like yeah. Open correctional gates in high desert. Yeah. Open our mind as we cast away oppression. Open the streets and watch our beliefs. And when they carve my name inside the concrete, I pray it forever reads.
Freedom, freedom, I can't move. Freedom, cut me loose. Yeah. Freedom, freedom, where are you? 'Cause I need freedom too. I break chains all by myself. Won't let my freedom rot in hell. Hey, I'ma keep on running, 'cause the winner don't quit on themselves.
go, Julie. Let's go.
All right, guys. You know that. Okay, I'm Kate Marshall. You all know it. Okay. But I got to tell you, I was your LG, but I had the opportunity to work for the president. I can tell you that this may be the it county, but he's the it guy. Now the president came here because he knows that we are the swing county in the swing state. He also knows that when we vote, we deliver wins. We did it for Reed. We did it for Cortez Masto. Are we going to do it for Biden? Yes, we are. Just like, so the Biden team is ramping up here, okay? They're opening offices. They're hiring people up here. Meanwhile, I don't know. I just got to say, you're so nice. But I got to say, what the heck is Trump doing? I mean, that guy, he's in so much debt, he's hawking shoes on eBay. I mean, seriously, the Biden campaign's ramping up. The RNC is shutting offices in Vegas. I kid you not. Meanwhile, our president, he's in the ring. He's in the ring. Just think about. Think about what he's done. Think about what he's done right here in Nevada. We're talking $2.2 billion in Nevada for roads, for bridges, for airports, for clean water, for internet on reservations. Am I right? What? Is it not union made, union built? Thank you. We're talking about, our president cares about vets. He doesn't just talk. He walks the talk. If 5,000 vets in Nevada have been able to enroll in the VA because of the PACT Act. Am I right? Alex Goff, a vet. How about prescription drugs? How about prescription drugs? You know, in Nevada, we got 1 in 3 people on prescription drugs. She knows. We got 1 in 3 people on prescription drugs. They're rationing their drugs. Well, the president's lowering the cost of drugs. He's making insulin $35. I mean, seriously, the president is fighting for you. Meanwhile, what's Trump doing? What is that guy stand for anyway? That guy says he wants to get rid of the Affordable Care Act. He wants to cut Social Security. And he wants to do something we don't do in Nevada. He wants to ban abortion. Now, we don't do that in Nevada. In Nevada, we say it's okay if a woman makes her own health decisions. Is that right? Now, I'm just going to tell you, it's serious. This is a serious business here we got coming up on the election, and I'm going to give you a real-world example of why the president is working for an economy that works for those who work. The president said he was going to cap junk fees, especially on banks. And the very next day, the banking bums, they told me I should say CEOs. The banking CEOs, they said, oh, you know what? We don't think Trump's that bad. And our president, who's in the ring, the scrapper from Scranton, can I say that? Our president stood up. He stood up and he said, yeah, how about an $8 cap on banking overdraft fees? Right back at you. He's in the ring. He's fighting for us. He's the Scrapper from Scranton, the President of the United States. Thank you very much.
I know who I'm voting for. Well, first of all, thank you. And in my house, kids rule, so don't worry, okay? No, I'm serious. And they want to let them run around, that's good by me as well. Look, the bottom line is, when you think about it, all of us in this room have one fundamental difference between us and Trump. I mean it sincerely. We have a different value set. It gets, to me, you know, I've been campaigning around the country and been in this job for 3 years, and it's, you know, it makes it, the more I thought about it, it's just fundamentally different. You mentioned vets. Well, you know, this is a guy who said when he wouldn't go up to visit a cemetery of veterans that they're a bunch of losers and suckers. My son was one of those losers and suckers. You know, it's just, I've never heard a president say the things that this guy has said. But the difference is he means them. He means what he says. With your help, we got elected the first time around. And this county and this state is really, really, really critical. Number two, my campaign manager here, she's had enough. She doesn't like all that noise either. Look, last week Donald Trump and I clinched the nominations. We're going to beat him again. We not only have this office, we opened up 4 offices so far in this state. 4, and there are going to be more. And folks, you know, we're going to keep making the case for second term by lowering the cost and creating more jobs. You know, we have grassroots support. You know, so far this campaign, we've had more than 1,300,000 people have contributed under $200 to us. 1,300,000, and 500,000 of those people are brand new from before. And so, and folks, you know, the fact is that the support around the country is real. I mean, it's not just for me. It's for Kamala. It's for the Democratic Party. The third thing is, you know, we've already created tens of thousands of good-paying jobs right here in this state as well. By the way, clean jobs, clean energy jobs. Trump lost millions of jobs. Millions when he was president. It's amazing how the nostalgia for a lost 4 years was. I mean, look, Trump passed a tax cut. Here's what he said. He said in Mar-a-Lago when he passed his last tax cut, which increased the deficit, exploded the deficit larger than any president ever has in a 4-year term. Here's what he said. He said, "I made a lot of you richer." This time out, he's saying, he was in Mar-a-Lago and he told a crowd of people, I want to look down, make sure I get it exactly right. He said, he described the crowd as, "I know you're rich as hell, but that's why I'm going to give you another big tax cut." The point is, it's about values. What do we value? Who are we? I mean, who are we for? What are we trying to get done? Folks, you know, Trump wants to undo everything we've done. You know, he wants to strip Medicare the ability to negotiate prices. I've been fighting my whole career as a senator and then as a vice president to make sure that Medicare is able to do what the VA is able to do. The VA can negotiate with the drug companies as to how much they're going to pay for all the medicines that come into the VA. Well, we've never been able to do it. We finally beat them. And not a joke. If we got back on Air Force One here and you picked any state, any capital in the world, and said, and brought a prescription you had to have filled by whatever the company is, American pharmaceutical company, you could fly to Toronto, to London, to Paris, to Budapest, anywhere. I promise you, they can buy it there for 40 to 60% less than you're paying for it. How many of you know someone who needs insulin? Okay, well, guess what? was costing $400 a month on average. It now costs $35 a month. And by the way, they're still making over 300%. You know how much it costs to make it? $10, T-E-N, $10. We also wrote into the law he wants to get rid of that, in fact, no senior, no matter how high their prescription trust bills are, and by the way, some of the cancer drugs are $10,000, $12,000, $14,000, $15,000, will never have to pay more than $2,000 a year for the drug. $2,000. And guess what? With your help, if we get elected in the next 4 years, we're going to change that to apply to everybody in America. I mean it. When I first passed the insulin, it applied to everyone. When they tried to get it reauthorized, the Republicans blocked it. But look, folks, the bottom line is he wants to undo everything we've done. You know, we've created over 800,000 manufacturing jobs nationwide. We created an awful lot of jobs right here in your state. And by the way, I was, every time I land here, I think of Harry Reid in Nevada. Yeah. Harry and so many of you talked about the fact that we needed high-speed rail from Vegas to California to Los Angeles. Well, guess what? It's coming. Well over $1 billion, man. And you're going to be able to get to, not that anybody wants to get to Los Angeles, but people from Los Angeles want to get to Nevada. Well, they'll do it in 2 hours instead of 4 and take tens of thousands of vehicles off the road and improve the environment. Look, folks, the fact is that there's a reason why we're doing so well. It's because of union labor. Not a joke. And by the way, that's not a joke. It's a fact. I didn't realize, although I'd been around, I know I've only been around a little, I look like I'm 25, 30. But I didn't realize back when the law was passed during the FDR administrations that labor unions were able to organize and the rules of the organization, that they passed a provision in the law that I didn't realize until a couple years ago, until about 8 years ago, that existed. It says if a president is given money by the Congress to spend on any American project or individuals, that president must use, 1, American products in doing it, and 2, must use American labor to do it. As I assume my labor friends will tell you, I've been the most pro-labor president in the history of the United States of America for a simple reason. They grow the economy. They grow the economy. I had the Treasury Department do a study. I asked them, I said, what is the effect of using union labor on the rest of the economy? Everybody does better when unions do better. Everybody does better. Wages up across the board. So, folks, look, I'm going on too long. I apologize. But that must be my traveling staff. One closing comment. We've never had a president who has said or done some of the things this guy has said. We have thousands upon thousands of people dying in Ukraine. One of the things that Dr. Kissinger said, Henry Kissinger said before he called about 10 days before he died, and asked if I would speak to him. And so he didn't call. He asked if I'd call him, and I did. And he said, he said, not since the time of, but way back when. Are you really? No, I'm okay. For the longest time, Europe looked over its shoulder at Russia with some dread. And he said, not since Napoleon have they not looked over their shoulder until we came along. He said, you've strengthened NATO like it's never been strengthened before. You've united Europe in a way. You've increased NATO and the border of NATO from bringing in Sweden and Norway. And he says, it's changed the world. This guy's talking about Putin like he's his long lost buddy, which he is. No, here's what he said. He said if a NATO member or European country doesn't pay their dues, then come in, do whatever the hell you want, Putin. Folks, this guy he has no basis on understanding what American foreign policy is about and what our national security is about. The idea that we'd walk away from a sacred obligation that existed since World War II and kept the peace in Europe is crazy. But look, I'm confident. I'm confident we get our message out to the American people. We're going to win again. But here's the deal. You're the ones that are going to do it. And it's not hyperbole. I'm not joking with you. It gets on down to, as we used to say, my football coach, all block and tackling, knocking on doors, calling people, going and making the case face-to-face with them. That's why we're opening these campaign headquarters. We're opening them all over the country, and we're going to continue to do so. So people can ask questions. People can look us in the eye and ask the questions, and we have answers for them. So the bottom line here is I feel really good as I go around the country, not a joke. And by the way, and the press are all good guys, but they report a lot of polls. The last 4 polls out, we're winning, okay? But guess what? None of these polls mean the damn thing this early on. So we just got to keep at it. Anybody want to ask me any questions? Yes.
The child family credits really helped save my daughter's family during COVID. Is there any possibility of bringing those back?
That is one of what I didn't get into, what I plan on doing next time out. We're going to bring back the child tax credit to cut child poverty in half. And by the way, it grows the economy. When women are able to go to work knowing they can have a safe place for their children, it grows the economy. In terms of education as well, by the way. We're in a situation where, think about it. You know, a lot of people haven't had the advantage others have had. They may come from a home that doesn't have the same background, doesn't have the same educational background, doesn't have books in the house. All the studies show, for example, if a child comes from a broken home where there are no books in the house and mom or dad are having real trouble, they're going to hear 1 million fewer words spoken, not different words, total words spoken than a kid come from a middle-class household. 1 million. And they start off way, way behind. But what we found out with significant studies being done, that if in fact you have a circumstance where you start a kid in preschool at age 3, 4, and 5, they have a 50% better chance, 50% of them go on to go all through 12 years and on to college, if in fact they have that chance. And it doesn't cost us much. How the hell can we lead the world if we don't have the best infrastructure in the world, we don't have the best education in the world, we don't have the best taxes, and so on. And the other thing I'm going to do, I'm going to talk about it down in Vegas, is that we're going to also make sure that we deal with all those things that affect people's daily lives. Look, you know, I come from a house, and I'll end with this. I come from a household where we lived in a 3-bedroom house. We weren't poor. But my dad, I guess we're technically lower middle class income. We never thought of ourselves that way. But we lived in a decent house, a 3-bedroom house, split level home with 4 kids, and a grandpa living with us. But there wasn't, on the trickle down economics, everybody talks about, not a whole hell of a lot ever trickled down on my dad's kitchen table. My dad used to say, for real, not a joke, my dad said, Joey, a job's about a lot more than a paycheck. It's about your dignity. It's about respect. For real. For real. It's about being able to look your kid in the eye and say, honey, everything's going to be okay. Well, that's what we're working on. We're building this economy from the middle out and the bottom up. When that happens, Everybody does well, including the wealthy. And by the way, I'm a capitalist. If you can make $1 million or $1 billion, go make it. Just pay your fair share of taxes. Okay? By the way, you know, we have, in the United States of America, we have 1,000 billionaires now. Since 1,000 was 740 when it was before the pandemic. Now it's 1,000. And guess what happened? You know what their average tax rate is, federal tax rate? 8.3%. I plan on raising it, and we're going to get it done if you give me a Democratic Congress, to 25%. That's all, 25%. And by the way, guess what that will do? That'll raise $400 billion over 10 years. And imagine what you're doing with child care, health care, and so many other things. Quick question then.
When you please support the registry, it's a law that just needs to be adjusted and will help 8 million immigrants, because you know immigrants are the base of this country. It's the registry.
All right.
It's a law. It's already 80 years old. Needs to be adjusted. Hasn't been adjusted for the last 40 years. So when you become the president, you will. I want you to.
By the way, get her phone number. I'll call you, okay? No, I'm serious. Okay? All right? I know. I got to go. Anyway.
We love you, We love you. You know Vegas wants him.
Hush not, child, and don't cry. Your folks might understand you by and by. Just move on up toward your destination. Though you may find from time to time complications.
There we go. Perfect. Thank you.
Thank you
met your wife, wonderful woman, and I teach history, economics, and government, and the lesson plans have just been writing themselves. I have been saying for the last 8 years, we're living in the most, we're not going to, we're living in the most extreme times. And what a time to be alive. We got to have
Mr. President, I want to introduce you to Chairman Gardapi from the Reno Indian Sports
Love
Colony.
the Indian nations.
Yes. Welcome to our land. Thank you for putting all the cabinets
By the
high
way,
level.
we have the most representative cabinet in American history. And by the way, you kind of like our Secretary of Interior, don't you?
Yes.
Oh, yes.
She's pretty good.
Hi, Mr. President. Hello. Thank you very much. I manage the Cultural Resource Program for the Reno Sparks Indian Colony, and we're really
Thank you.